And good morning, everyone. Thank you for joining us on this live webinar with me, none other than the attorney Nazli Williams, or Nazli Patton Williams, from the firm of attorney called Patton Williams Attorneys. Nazli, how are you doing today? I'm very well, thank you. I know we had a bit of a technical challenge today, solely because the sound issues didn't work so well, but just give it one second and we'll be ready to go.
Yes.
Nazli, I'm just putting your sound on quickly. 1 second. I must just get this thing to work. Okay, there we are. I didn't test it. Okay, now your sound is perfectly. Nobody heard what you said early on. So, Nazli, how are you today?
Again, I'm good, thank you. Thank you very much. How are you on that side?
I am very, very well. Everything working okay. The sound is good and the signal is good, and we're ready to roll. So, Nazli, today's topic, interesting topic, and I would like to deal and follow up on our previous discussions. The attitude a client should have in dealing with their matters. Toughen up. Only Pacific case. When they deal with domestic
Yes.
violence, child custody matters, they need to, have a bit of guts and a bit of, hair on their teeth. What is your view on that topic?
Mm. Well, the first thing I think that people should know is that, especially people who are what they call in the United States pro se, that means that you are representing yourself. If you are choosing to represent yourself in a legal matter, remember you are in effect choosing to be your own attorney. So if you're going to be your own attorney, you're going to have to act like your own attorney. You're going to have to do the work that an attorney would have done for you. Okay. Some matters are too complex and too involved for a person to be doing as an underrepresented party, I admit. And then there are certain matters that you can do on your own, like for instance, the maintenance court. You're supposed to be able to do that on your own, although it's not that simple and it's not that straightforward. But the ideal or the intention of the legislature or of the concept of the maintenance court was always that people should be able to do their own matters in the maintenance court. So if you're going to be doing your own matter, you are telling yourself or you are telling me that you're going to be your own attorney. But then I find that many of these people who are representing themselves, they don't act like the attorney in their matter. They are still acting like the aggrieved party. So you have two hats on. You have the hat on as the victim or as the complainant or as the applicant, and you are your own attorney. So they forget that they are now also their own attorney. So you have to not separate yourself from your matter. You can't, it's impossible. That's why it's recommended and preferred that you get an attorney. But if you can't do anything else, you need to accept that you are responsible now for putting your own case before the judge or the magistrate. You are now responsible for the litigation of your own case. And if you're going to be litigating your case and you want to win it, then you obviously need to do what an attorney would have done, which is usually you start with your research. So going to court, not doing your research, wanting to represent yourself is like going to run a marathon without having prepared for it. You didn't adjust your diet, you didn't exercise or take test runs or went and jog or whatever you do to prepare for a marathon or for the comrades or whatever. Nobody just shows up at the comrades and starts running. No, there's preparation to be done. So the same with a court case. If you're going to be running your own legal matter, uh, um, you're going to prepare, you're going to go do your own research, you're going to go see what the court decided in similar matters to yours. You're going to see what arguments you're going to use, and you can't just use an argument, I was hurt and I was pained and he's supposed to or she's supposed to do this. No, the judge doesn't want just your facts. The judge wants legal argument, and on your legal argument the judge is going to, or the magistrate is going to, make his decision. So please, if you're going to do your own legal matter, it is crucial and it is paramount, and it is plain and simple important that you do your research. If you do have an attorney on record, okay, obviously you've got your attorney that is doing all the thinking, all the research, and is going to present your argument to the magistrate. He knows what facts are relevant, what is not. In that case, it's another story. You're going to depend on your lawyer for that. But then you must still take responsibility of your case by providing your attorney with the facts that he needs, with the information that he needs, with the proof or the documents that he needs, because the attorney just as much cannot just go and rock up at the comrades and start running. No, your attorney needs to prepare. How do your attorney prepare? Your attorney will have a consultation with you, or maybe even more than one. He will ask you for your side of the story. He might ask you for the other side story. What does the other side say? And then he's going to focus and hone in on what do you have that he can use to prove these allegations that you are making. He's going in a maintenance matter. He's going to ask you for your bank statements. He's going to ask you for receipts. He's going to ask you for sometimes even communications between yourself and the other party. He's going to ask you for sometimes even tax returns. He's going to ask you for pay slips. So you can't not take responsibility of your case just because you have a lawyer. Because I can't go and tell the magistrate that my client only earns 5,000 Rand. Where's the payslip? Where's the bank statements? Well, my client is kind of working today and he can't really give me the pay. No, the judge is going to say, sorry, but your word is not evidence. Okay, I need evidence that this is your client's position. So whether you are represented or not, you need to take responsibility of your court case. You are the one driving your case. You are giving your attorney the petrol, the car, the vehicle, the key to the vehicle. Or maybe you're not the one driving. Maybe the attorney is the one driving, but the attorney still needs the car from you, the keys from you, the fuel from you. Okay, you need to take responsibility. Muhammad, I often find it that if clients make emotional allegations, especially, most often these things are not legally enforceable. Meaning, for instance. Let's make just a petty example. My husband forgot my birthday in last year. Okay, that doesn't prove anything. It might prove that he's emotionally unavailable, or that he doesn't really care about things like birthdays and Valentine's Day and whatever the case. But although it hurts you so much that this person who is claiming to love you has forgotten your birthday, the only thing I would need that information for would be maybe as one of the grounds of divorce, which would say, there's no love and affection between myself and my husband anymore. But I would put it in like that. I'm not going to say to the judge, but he forgot a birthday and that is why you should make this order. So this comes now away from taking responsibility. This comes now to the fact of relevance, that certain things are just not relevant. Okay, you are going to increase and inflate your legal bill superficially if you are going to spend countless hours on explaining to your attorney how something made you feel. The judge and the magistrate is not interested in feelings. They are interested in facts, and they are interested in legal argument, okay, and in the law. So your facts might culminate to something like there is a lack of affection and respect. It might culminate to that. But the actual happening, how it made you feel, how you didn't even get a birthday cake, those things the judge are not interested in. So do not burden your case or your attorney with things that they cannot use you can mention it, because that is part of giving your attorney an idea of what kind of an individual is on the other side. But don't insist on putting something in a letter to the other party. You forgot my birthday. Don't insist on put it in pleadings or in affidavits unless it is relevant, and your attorney will tell you what is relevant. So that is basically my in and out about when how clients must take responsibility of their cases. Yeah, I
Yeah,
don't know
and
if I've explained it properly or clearly.
no, no, you don't. You don't. Thank you very much, and I'm with you 100%. And that seems to be a bit of a weakness in a case, whereby when clients come see me the first time, they spend the first part of the consultation bad mouthing the other party. And honestly, I can many of these webinars and consultations. I'm doing a lot of them via Zoom as well. Is that one party wants to change the other party's personality? And I asked him, how
Mm.
can I do that? I mean, it's impossible. The same way, I know you want to speak, Nazli, give me my 2 minutes. I they want to change the other party's personality, and at the same way, I ask him, can he change your personality? Can he make you be a bit more lenient to have keep contact to the minor child?
Mm.
Can he make you a bit more different? You know, he cannot do that. The same way, how can the judge or the court change another first party's personality? So those are irrelevant issues. Um, he's always likes hanging out with his friends. He doesn't give a lot of attention to the minor child when he's in contact with the minor child. The same way you must probably do exactly the same. So focus on what's important. The possibility can you care for the minor child. And when it comes to these type of matters in Nazli, people deal with a lot of petty stuff. For example, I gave him contact. We separated. I gave him contact, but when he has contact with the child cries. Then I come to him and say, "Why is the child crying?" But in the same way, Nancy, I'm certain you are mommy as well. Many times you had a child in your hand, the child was crying. Imagine your husband comes to you and tell you, Nazli, why can't you care for the child? Why is the child crying? Is it natural how the child cries? So I'm going to the Nazli. I'm with you 100%. Focus on what's important, and and that will give you greater success in your case. Going further, Nazli, I have a lot of questions for you because you're really passionate about these type of matters. You want to, you should have become a lecturer, but I think you're better litigator. Nestle, when it comes to the issue concerning domestic violence and gender-based violence and these type of things, I think that is prevalent now. What is your view as a lawyer? Yes, besides going to the court, should someone toughen up there as well? Should you stand up for yourself? Should you stand up for your rights? Should you just become a victim? What is your view on these type of things?
Yeah. Um, you know what? My first instinct when someone approaches me with regards to domestic violence, I think we have discussed a little bit of this in a previous webinar, where I find that some people are just not ready to let go. And there is nothing that an attorney can do to make you ready to let go. I think it feels so familiar, this topic. I can swear that we've discussed this in a previous webinar
No,
where
Desiree,
I've even
we
explained.
we have
Yeah.
discussed it, but remember some people watch this webinar only and they never watch the previous
Yes,
ones.
yes. No, I just don't want to bore people with being repetitive. So if you haven't heard this before, then obviously then it's wonderful. But I don't want to bore you guys. But I mentioned that there are different types of people approaching me. I mean, personality wise, circumstantial differences in these people that approach me. The one that I get most often, which I now find is most often, is that people sometimes come for an ear. They come to an attorney because they are in an abusive relationship, and I can figure out within the first 5 minutes whether that person is there for help and assistance, or whether that person is there to basically come and complain about their situation, not yet ready to do anything about their situation. And for me, it is important as an attorney who charges for my time that when you come to me as an attorney, I'm not saying you're coming to me for help, because I'm going to call the cops if you're coming for help. Okay. That's the first thing you do when you are anyway in an emergency. You call the police, because this is something I want to explain actually before we dive into the types of people that come to me. An emergency, or when you are in danger, please do not call your attorney. Your attorney cannot take you out of your your emergency situation. Again, there is another kind of professional for that. If you are, let's make an example, you are in your home, you and your spouse are in an argument, your spouse starts to get violent, starts to throw things around. Do not call your attorney. There is nothing your attorney can do about your emergency situation. You need to call the police. 10111. Your attorney is not a response worker. Your attorney is there to enforce your rights once you come and see your attorney and say you want this kind of relief. If you are in an emergency situation or in a domestic violence situation, the police is your port of call. I find many times that I get messages at 2 o'clock, 3 o'clock in the morning where the person, not a client, maybe someone that Googled quickly, attorneys, and the person would call me or SMS me or text me at 3 o'clock in the morning saying, please help me. My husband is throwing things at me. Why are you contacting an attorney when you are in danger? When you are in imminent harm's way? A lawyer is not a response worker. They are not there to respond to emergencies where you are in physical harm's way. You need to call the police. So now let's get back to the situation where what kind of people come see me for domestic violence matters. The ones who come and see me are mostly people who are not ready. They just want to come and tell the story. You as the attorney can't do anything. You can tell them their rights. You can say, listen, you need to apply for a protection order. You can do it on your own, or I can assist you with that. Remember to attach that to your affidavit. Remember to attach this to your affidavit. That is what the attorney can advise. But that person will go and you will never hear of them again until maybe a year later or 2 years later, where they come to you and they want to get divorced. And it's the same story. This is what happened. This is what I know the story. You told me the story. So are you ready to get divorced now? You know what? I actually just wanted to come find out what's my rights. But now this person already came to you a year ago for a domestic violence matter. These are people that are not ready, and there's nothing wrong with it. I'm not saying there's something wrong with it. I'm just telling you that when you come to a lawyer and you don't hear what you want to hear, or you are not ready to do what the lawyer is advising you, do not get impatient with us. Do not think we don't know how to do our jobs, because a lot of people get very irritated when you tell them you need to apply for a protection order. And then the person is telling me, but I know that. Okay, so why are you here? I mean, that is your remedy. That is the law. The law says that if you are in a domestic violence situation, you apply for a protection order, whether it's financial, economic abuse, or whatever the case may be. So what do you expect the lawyer to do now? If you don't want to apply for a protection order, well, I don't want him to get locked up or her to get locked up because it's the mother. Okay, so you tell me now, what must I now tell you? Because this is your remedy. And then I slowly learned that these people just want to be heard. They want you to listen, and whenever they're ready someday, they will come back to you. So don't think I'm getting annoyed or anything, but I don't want you to get annoyed, you as the person coming to see us, because we can only give you what the law says we can give you. And if you know that already, then I am assuming that you are just coming to see me to hear it again, because we can't give you anything other than that. And then another type of person that comes to see me are people who are slowly moving into the direction of leaving, and they just want to establish their rights, meaning they are now at step one, where they have realized that, you know what, it's not going to work. I'm in a domestic violence situation. Maybe it's not physical at that point, but you can see it going there. And I think I'm going to leave at some point because it can't go on this way. I've already given an ultimatum. So I want this lawyer to tell me, what are my rights should I decide to leave this person? Okay, so now I'm giving you your rights. Okay, I'm telling you, you know what, should this happen, you must apply for a protection order. You know, put a little bit of money away if you can in a savings account, so just in case you need to get a place to stay. Work out your kids expenses so long, because you might have to apply for a rule 43 or a rule 48 in the magistrate's court. You know, just get yourself ready, try to separate some of the assets already. If you've moved out, or if he's moved out, you know, decide now already what you're going to let go. And actually talk to your spouse, and see that should it come to that far, how are you going to divide your responsibilities in respect of the children. So these people are people that are coming to prepare for the inevitable almost. Okay, and then there's the other person that comes and says, I have had enough. I'm in a domestic violence situation. He or she has now finally become physical. I was hoping it could change. I've given it 6 months, and I am here to get divorced, or I want to apply for a protection order. I've already spoken to my mother and my sister. They're going to house me for a little bit, and all those kind of things. And they, what is your deposit? Account details, where's your mandate? They sign the mandate, there goes the SMS, deposit is paid. I immediately get onto my settlement agreement. Those are people that are now ready, they're ready to go. So in general, when it comes to domestic violence, the first port of call when you are in danger, when you are experiencing domestic violence in your home, you need to phone the police when harm is imminent. You need to apply for a protection order. You can come to a lawyer later, once you're safe, once you're out of that situation, because the lawyer cannot physically rock up at your house and remove the dangers. That's not our job. We're not trained for emergency responses like that. We do urgent applications, yes, where we will do an urgent application to interdict someone from doing something, or to make someone do something or not do something. But we cannot go for an urgent application at 3 o'clock in the morning to stop someone from throwing an ashtray at you. You can't do that. That's the police job, to come and make to remove you, or the person, the violence, or make it stop, or arrest the person. Nothing that your lawyer can do at 3 o'clock in the morning. And this is another thing that inflates legal bills, because once your client has retained you, they want to employ your services across the board for everything. No, you have appointed me to get you divorced or to get you a protection order. That is what I do. I do not separate fighting couples. The police must do that. If you guys are fighting, that's their job. They get called out to domestic violence disputes. I do not go and pick up a child that should have been returned at 5 o'clock. No, I'm going to bring an urgent application for the return of the child. You're going to email me or phone me and say, listen, it's been 2 days. He or she was supposed to bring the child back on Friday. What can we do? I'm going to say, listen, let's first try and speak reason. Phone the other party or the other party's attorney. What is your plans? Or what are your plans? Okay, so if you're not going to return the child, unfortunately, we'll have to proceed with an urgent application. That is what the attorney does. So you phoning me, telling me it's already 6 o'clock and the child was supposed to be at 4. There's nothing your attorney can do. Not at that point. You do not have enough grounds even for an urgent application, because a person is 1 hour late in dropping off the child. Okay? I feel it's the attorney's responsibility, actually, to explain from the start to the client what is your job as the attorney, what they can help you with, what they cannot help you with. Because too many people are very surprised when they get this huge inflated bill and they cannot understand how this matter can now be 50, 60,000 rand, but you've only like applied for a protection order. But if you go to the correspondence shows that you emailed at 3 o'clock and actually expected back and reply at 3 o'clock. You phoned 5 times on Monday because the child was 1 hour late, and the attorney already told you, let's give it a day or two so that there can be reason for urgent grounds. Okay. You insisted that the affidavit must be drafted today because you don't want to wait 2 days, and the attorney had to cancel 4 other appointments because you want it done right now, and the attorney is obliging, meaning the attorney is now literally only billing on your file because they are spending all their time, their billable time, on your file. But it's things that is not giving you the relief that you seek, even though the attorney told you it's not going to help at this point. So now you wonder at the end of the month, why is my bill so high? It's because there are things you are bringing to the attorney that is not within the attorney's mandate. It's not their job. The police was supposed to do that. A social worker was supposed to do that. A child psychologist was supposed to do that. The priest or the bishop was supposed to do that. Things like that. So yeah, first port of call, domestic violence. If you are in danger, phone the police. Get a protection order. Please know what your attorney is supposed to do for you. Only ask your attorney to work within the scope of the mandate. Make sure your attorney explained to you at the beginning what is the scope of his mandate, meaning what he's supposed to do for you or she is supposed to do for you. Do not go outside of the mandate because you are going to get charged for these things. Because remember, me picking up my phone, me responding to you chatting to me on WhatsApp for 15, 20 minutes. That is 20 minutes. I could have drafted a letter for another client and could have built, maybe if I charge 1,000 Rand an hour and it took me an hour to draft that letter, that's 1,000 Rand. So you chat with me for an hour. That's 1,000 Rand for a letter that I could have earned so that I can pay my bills at the end of the month. But now we are discussing things here that is not furthering your case. So I'm not making money on this side, which I need to make because I have staff to pay, I've got an office to pay, I've got kids, and I'm billing you for time that you could have spent better. You could have used that 1,000 Rand that I'm going to have to bill you now. We could have used that for a letter to the other side at some point. So responsibility goes everywhere, not just domestic violence cases, maintenance, uh, 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 um, divorces, I don't know what other cases, but always remember that you pay for the services of an attorney. Know what your attorney is supposed to do. Your attorney is not a police officer. They cannot respond to emergency situations. And apply for a protection order because that is the advice and it's not going to change. You're going to have to apply for a protection order. If you don't want to get your partner arrested, then the protection order is going to mean nothing. There's no other things you can do. Maybe you can move out, but maybe you're not ready. The attorney can't make you ready because that's what I tell my people. If you don't want this person arrested for violating the protection order, what else can I do? You will have to move out then. No, but I can't move out. Where do I go? Okay, so now what now? What must I do now? What can I advise you now? You don't want to take my legal advice. You don't want to take my alternative to the legal advice. Where are we going now with this? 2 hours later, you bought 2,000 Rand, no solution. Yeah,
Nazli,
that's my view.
Nazli, I think we can maybe like summarize on this basis. You know, lawyers and attorneys, we focus on the office. We work in the office. We draft documentation. We present it to the court, and that's our DLM office, court,
Yes.
and maybe whatever else we do in that regard. We might go to a location if it's maybe required because they say it's a scene of a
Yes.
crime, the motor vehicle accident happened over there, or the theft happened there. That's the only time we go there. But we have police officers who have an obligation, to make sure that there's peace all the time. We have social workers, psychologists. Those people are there for a purpose, and we as attorneys and advocates and lawyers are not trained, you're right, to do that. Our job is to fix problems as they arrive. We can't change your personality and so on. And as while you were speaking, and I appreciate what you have mentioned, and I've learned a lot from you as well. Something very interesting is that someone, the mother, for example, let's say we deal with your fictitious scenario. I mean, we're all being fictitious over here. We're speaking about nobody specifically. The mother will say, you know, the father, he likes wasting money, he likes buying money on jeans and clothing and going on restaurants. But you again, you spend money on legal fees unnecessarily. You like phoning a lawyer at any time of the day. You like asking the lawyer to make these, unreasonable applications to court, with are no legal basis. Therefore, luckily, you have scruples, Nazli, and I like that about you. You won't unnecessarily, bill a client 100, 200,000 rand. If it's not necessary, many lawyers do that. Maybe you'll be on the other side of the field, and you'll have to defend it. But many people and many clients are quick to say the other party is acting unreasonable. The other party, is abusing, whatever the case may be. But you yourself, in the manner in litigation, you are being very childish when it comes to that. You might have the money, that's fine. You might have the money, but why, you know, litigate on that specific basis? So Nazli, thank you for that, and I appreciate it. And you always have something additional to add to the story. Wonderful. So maybe we can go on a different topic. I did put on the screen on top of the family legal talk. So we're discussing family problems. You can't see it. It's on the stream. When it comes to fighting over the child, let's say the parties cannot come to an agreement regarding the child. They live in the same house, for example, but they can't come to an agreement as to who will be taking the child with. What is a quick situation to deal with that from a legal point of view? Um, they are now tired. Mother wants to leave. Can't come to an agreement. I have my own challenges in answering that question, but maybe you can try it first.
Can you hear me now? Okay. Okay. So are you asking me if people are now ready to separate ways and they are having difficulty deciding who's taking the child? Okay. There is a benchmark or a golden thread that runs through family law. In fact, in my opinion, it runs through everything, the whole law, the legal system. But let's bring it down to family law. There's a golden thread that runs through family law, and that is that the best interest of the child is paramount. So whatever decision you and your spouse is grappling with, if it's not in the child's best interest, then it's not going to happen. You're not going to get past the family advocate, not that they're the final authority on the child's best interest, because you can bring your own expert to prove otherwise. Okay, they just make a recommendation to the court, right? They like the court's little right hand, because the court doesn't know what the best interest of the child is. The expert knows, and the expert is giving the court the necessary report to with their recommendation. And if you don't agree with it, you're going to get your own expert, and the expert is going to show the court, listen, I understand what the family advocate is saying, but that's not really what we think. We found that this and this and this is why it's in the child's best interest. But you're not going to survive the scrutiny of any decent expert or the court if whatever decision it is that you make, which is the child is based with me, if it's not in the child's best interest. So what I recommend to parties, I know it's difficult, because remember, you are at the end of era, you are at the end of is that a fly? You are at the end of your marriage, and it's sad. Maybe there's fighting, maybe there's arguments, there's emotions involved, and all of those things. So nobody wants to talk about anything other than their own pain and their own hurt. I understand that. But I would recommend you go see a mediator, or maybe even a child psychologist. I don't know. Like I said, I'm not the expert on what the child's best interests are. That's why I will send you to the expert, so I can also see. I just know what's best for my kids. That's all. I don't know what's best for your kids. I don't know what is your children's setup. Maybe your child has a learning disability. How will I know what is in the best interest of your child with a learning disability? I don't have experience with kids with learning disabilities. Maybe your child has an allergy. Me as the attorney, my child has one allergy and I know how to manage that allergy. I can't tell you what's in the best interest of your child with the other type of allergy. So there are professionals for these things. So if you and your spouse are having difficulty deciding how the arrangements are going to work in respect of your minor children, you know what? Spend the money. Go to see a mediator, because the damage you do fighting about what is best for this child, not being on the same page, it's extending your pain. It is inflating your legal fees superficially, because you're fighting about something that even your lawyer can't answer you about. Because remember, we're not the experts in child care or child best interest of the child. We are not. So again, it's not going to help calling your attorney, writing emails to your attorney. He doesn't, he says he wants the child, or she says she's, because she's the mother. What must your attorney respond to you other than, we will have to ask the family advocate to investigate. The family advocate is free, by the way, if obviously if you don't have the money for an expert. But I'm talking now about, if you could, if you don't want to wait 6 months with a family advocate for the investigation, rather just pay the 500 or the 800 or the 1,000 rand an hour for a couple of sessions with a mediator. Because those couple of thousand, say for instance you pay 4,000 rand for a mediator, or for a child psychologist to make a recommendation, or somebody capturing the child's voice. Say you go for somebody that captures the child's voice, maybe also listen to what the child is saying. The child is already 14 years old, 15. They can actually also have input. They don't have right of consent, but they do have the right to make their views, to express their views. Okay, so now you spend 4,000 rand to just get some sort of an idea of what is in the best interest of this child. That literally saves you 250,000 rand in legal fees, having to fight it out through a trial. And I'm not exaggerating. I am not exaggerating. We can either go to trial, and the family advocate said something that you don't like. Now we appoint our own expert for 40,000 rand for the report. And now that expert doesn't say what you want to say. Now we have to find another expert, another 40 grand. We maybe appoint the advocate now, which we will, because I mean, we're going to the High Court. We need an expert in legal matters as well to run this case for us. Now we've got the advocate's fees, we've got the attorney's fees, we've got the expert fees. Time you need to take off work. You need to take off work for appearances, or for the trial, or for testifying. 300, 400,000 rand later, because you needed to prove to the court why this is now, where you could have just in the beginning spent the 4 or 5 grand. Go and sit with the mediator, and the mediator is doing reality testing, trying to put situations forth that you haven't considered, because that is what the mediator does. They do reality testing, meaning they listen to your version, they listen to the other party's version. They cannot give legal advice. They cannot recommend to you a solution. All they can do is try and get the parties' interests to overlap. So what is your interest and what is your spouse's interest? It's the best interest of the child, hopefully. Okay. So now the mediator is trying to overlap those interests, where the mediator says, okay, so you guys don't agree on anything, but you both agree that the child should stay where it will be in the child's best interest. So that is one thing you have in common, but we need these two poles to move closer so that we can find a midway that might not be a win to both parties, but at least both parties won't lose, because somehow, there's not going to be a win and lose situation in mediation. It must be a midway that both parties can live with. So now you don't want to spend the 5,000 for the mediator, but you want to go to trial. And then guess what happens after 2-3 years of litigating in the High Court? Almost R1 million in legal fees later. Guess what happens? We are upset with our lawyers and our advocates because it cost me R1 million to get divorced. In the meantime, you were advised that there were other recourses you can settle. Maybe you will be happy with a little bit less, so we can avoid R1 million of legal fees. Maybe we can spend the 5,000 rand on the expert, or the 40,000 rand on the expert, to get some kind of professional view of what we want. Is it really feasible, or is it in the child's best interest? But we are litigating out of principle because we are hurt. We want to beat the other party. We want to leave them with nothing. We want to you know what, I even forgot the point of the question, but what I want you to take away from this is that the children's best interests are paramount, and it's not up to you. If you guys are going to fiddle about the child's best interest, it will not be up to you in the end. You're going to lose control of your child's best interest, if you can mention it like that. If you talk about it and go to a mediator, try to resolve it, you retain control of the outcome of your matter when it pertains to the children. You still can say, but listen, why don't we make it 3 days a week? Why don't we make it 2 days a week? So it means you can still manage your control over the situations. Once it's with the court, once it's with the judge, you lose control out of the outcome, because the court will decide now what is in that child's best interest. So when you fight with your partner about the child, where the child is going to live and whatever, don't be selfish, because the court is not going to fall for that. Do not be unreasonable, because the court is not going to fall for that. Do not be spiteful, because the court is not going to fall for that. Do not be unnecessary, because the court is not going to fall for that. Think, what is in the best interest of my child? My child has allergies. I know how to administer the EpiPen or Epi something that they call it. My spouse works night shifts. He or she doesn't know how to administer this medication. So obviously it's not in this child's best interest to go reside with a parent who's working night shifts, plus who cannot manage the child's illness or allergies or whatever. If that person can't understand that, then unfortunately, it might end up in trial, because obviously you're not going to go let your child live there, because they're not going to get the medication and there won't be anybody looking after the child. Okay. But if you're not going to at least suggest to the other person, let's go see a mediator who's impartial, and that it's going to be without prejudice, those discussions there. It's going to be confidential, meaning you don't have to be afraid that whatever is talked about in mediation, that's going to be used in court. So it's a no strings attached kind of thing. It's voluntary. Mediation is voluntary. You can get up and go anytime. So if that person is going to come into mediation and that mediator starts to do the reality testing, they're going to ask, okay, so do you work at night? Yes, I do. Who's going to take care of the child when you're working? My girlfriend. Does your child have allergies that requires medication every hour? Yes. So is your girlfriend going to wake up every hour during the night to administer the medication? Now the person is starting to think. Because remember, while you're fighting with that person sees no reason. That person is like, you just want the child to spite me and all of those things. They don't think about the practical implications of their situation. They don't think even of the child's best interest at that point, because we are now angry. But now the mediator then is like reality testing you. They bring you, they make you think of the possibilities of everything that can go wrong and everything that can go right. But now at least the person is like, yeah, my girlfriend, she's not going to wake up every hour. Now you can see reason starting to return. Okay, so your wife, your soon-to-be ex-wife, does she work at night? No, she doesn't. She's at home. Does she know how to administer the child's medication? Yes, she does. Who usually looks after the child when the child is sick? My child. Okay, so, my wife. So, okay, so if you were to think now, do you think that it would be good for your child to be sick and being with your girlfriend that they don't really know at night? Or with their mother, who they are usually with when they are ill? Do you think it's in the child's best interest that the situation change for the child? You will quickly see the springs, the balletjies, it's going to start rolling. That is why we talk about these things, to show the person that we bring everything back to the child's best interest, and your situation, it doesn't make you a bad parent if you can't accommodate your child's needs as it stands. Because remember, the court wants to enforce, not enforce, the court likes for the status quo to remain. Status quo meaning the court wants things to be as close as possible to what it has always been for the child. The court does not want the child's circumstances to be disrupted because of your fighting and your divorce. So the child has always been in that school. The child preferably should remain in that school, because we do not want to disrupt our children's lives when we separate from our partner. So these are the things we need to think about when you consider who the child is going to live with. And I just can't get people to see this without having to first litigate 2, 3, 4 rounds in court, 80,000 rand later. And now people are starting to think not of the child's best interest, but of the money. So now whatever decision is being made is now not because, you know what, I see, okay, I work night shifts, I won't be able to inject my child when he needs to be injected. Now it's like, this attorney is getting rich out of me now, so maybe we should must settle. And then you leave angry with your attorney because 80,000 rand later, and you still don't have the child with you, you still don't have an order, and it's just that it's becoming too expensive now, and these lawyers are getting rich out of us. But why did we just not do why did we just not mediate? Because your attorney, a good not it's not even a good attorney that's necessary to tell you that we are now required to mediate before we approach the court with an application or an action proceeding. So if you're going to be like stubborn and say, I'm not going to mediate, she is ridiculous, he is ridiculous, they won't see any reason, and just issue the summons and fill in there, I don't want to mediate. Do not do that, because you are not only, there's a fly that is disturbing me and it's breaking my stride. um, uh, uh, you are not only affecting your child with all this commotion around him or her, but you're also doing yourself a disservice by fighting and paying and paying and paying and paying. Meanwhile, back at the ranch, it is something that cannot easily be sorted out. Not easily, it's never easy, but something that can at least there must be at least an attempt to try and talk about these things and look at the child's best interest, the reality of the matter. That's why we do reality testing in mediation even, you know. And so please, if you are currently in a situation where you are fighting with your spouse about who's going to take primary care of the child, don't think of it as something that you're taking away from the other child, other parent. Remember, a child is not part of the division of property. It's not part of the division of debt. It's not a pawn. A child is not something that you can spite another person with, because that child loves both their parents. So when you are doing anything that is not in the child's best interests, even if that means not allowing the child to visit the father or the mother or living with the father when it's in their best interest, you are hurting that child. You are taking away half of that child's heart. You are telling that child that this thing that you love, I'm going to take it away from you because I'm hurt and I want to feel better. I want that person to experience pain because they broke my heart, or they cheated on me, or they did something to me. And the only way I can hurt that person and to make myself feel like I've vindicated myself and the revenge I want is by taking something that you love. Does that make sense to you? Does it make sense to you to take something away from your child, hurting them to hurt that person? You're not just hurting that person, your spouse, you're hurting that child. All that child knows is that there's two people who I love so much. And I don't know why my mom or my dad is so heartbroken, but it looks like they want me to be heartbroken too, because now they're taking away mom or they're taking away dad. Why can't I see my dad? Why what did I do? Why am I getting punished for? It's like, so, think about something that you love. Just very quickly, take a second and think about something that you love, even your child. Think about it. Just think about it for a second. Now imagine me coming and taking away that something from you. Not because you did something wrong, but because it will make me feel better. So I come to your house and I say, I'm going to take your child now because your uncle hurt me last week. And I don't know how to hurt your uncle, but I heard that your uncle loves your child. So I'm going to take your child now, and that's going to be the revenge that I've been seeking. Do you deserve that pain? Do you deserve to bear the brunt of someone else's pain? If you are keeping your child away from your spouse, or you don't want your child to live with the other person, even though it's in the child's best interest, if you are doing that purely because you want to hurt the other person and not because it's in the child's best interest, then you are literally using your child as a beating stick.
Nazli,
You are
on
taking your child.
no, no, no.
Yes.
On that point, I think we're running out of time here. We're going past the 50-minute
Oh,
mark. And Nazli, no, Nazli, thank you very much for that. I need to also start the day a bit now, the afternoon shift. Um,
yes, yes.
Nazli, thank you for the question. I learned a lot from you, and it's amazing how time flies. It's like, we're like now
Yes.
almost an hour over there. So we'll continue on this topic next week. I think all our viewers are very excited to hear, and you're teaching them invaluable lessons. You don't find these lessons in the textbooks. You don't find it in the textbooks. You don't find it from many other lawyers. You are actually willing to give it to us, and we appreciate it very much. Nancy, I need to cut the video short because I need to be out of here also. Your details are on screen. Patton Williams Attorneys, info at pattonwilliams.co.za, and the cell number 07250090909. People can contact you, they can WhatsApp you, they can connect with you. And from what I can see, should I be in difficulty, heaven forbid, but you're the proper lawyer for me, and that will be wonderful. Nazli, thank you for your time. Any quick final words you have? Not on the topic, but anything you want to say quickly for 30 seconds. Otherwise, we'll have to cut this video short, and it will be available on the study on
Yeah.
the stream.
Choose to be happy. Happiness is a choice, okay? Choose to be happy. Choose you. You deserve to be happy. Love yourself, and whatever decisions you make it in your children's best interest. And remember, you don't owe anyone any explanations as to why you deserve to be happy. You deserve to be happy. Fact, klar, finishing klar. Okay? Enjoy the
Thank you.
weekend.
Thank you. And it's Valentine's week, the week of love or the month of love.
Yes.
So I heard the word love a lot of times. I don't hear the word love much from attorneys and lawyers. But thank you. And we got a comment over here on the webinar on the live thing. Says yes, thank you for your valuable lessons. Definitely looking forward to the next one for next week. So wonderful, Nancy. Thank you very much for that. Have a wonderful day. Stay on the line,
It's a
please. I'll
pleasure.
chat you in a minute's time, but stay on the line. Let me in the stream and I'll chat you now. Thank you. Bye bye.